Capitol. We'll let you watch as they get ready for this hearing, and we wish you a good weekend.
This guy right here. Yeah, here, let me, I've got a volume out there.
The hearings for the confirmation of Judge Alito for the Supreme Court of the United States will now reconvene. I've just been discussing with Senator Leahy the allocation of time, and we had 7 judges who testified yesterday who exceeded the 5 minutes. I thought it the better part of prudence to not bang the gavel, but allow them to go on. But they did take some extra time in the 7, 8, 9 minute range. So I just said to Senator Leahy that we'll give 7 of the witnesses selected by Democrats 5 extra minutes, or he can allocate the time as he chooses. I don't want to split hairs over how much the exact time was, but I think it's very important to keep the balance, and we did that in the selection of the number 30. In the past, it had been divided about 18 to 12, with the majority party taking more, but we have worked out at the arrangement of 15 to 15 to keep it level.
Mr. Chairman, if I might on that, you have been fair in this. And ultimately, of course, everything has to be determined based on what the nominee says, but the public witnesses are important. You know, we're deciding whether to replace Justice Sandra Day O'Connor with Judge Samuel Alito. I think they help focus, as the witnesses yesterday did, on aspects of his record in the bench with respect to civil rights and privacy rights. These are longtime pioneers in our nation's sometimes rocky journey toward equal justice and respect for women's rights. They're the people on the front line today. Going to hear from representatives of minority communities. We'll have a number of written statements. And as I've said over and over again, we're the only 18 people to get to ask questions on behalf of 295 million Americans and generations for a long time to come. So I think these hearings are important. Again, I thank you for your courtesies and your fairness in keeping it going.
Thank you very much, Senator Leahy. We now turn to our first witness on a panel, on our next panel, Professor Nora Demlender from the Hofstra School of Law, teaches and has written widely on criminal, comparative, and immigration law, managing editor of the Federal Sentencing Reporter, and serves on the executive editorial board of the American Journal of Comparative Law. Bates graduate, summa cum laude, graduate from the Yale Law School, 1992. We have a heavy representation of Yale Law graduates here. That's a very healthy thing. And was symposium editor of the Yale Law Journal. I didn't know there was a symposium editor. There wasn't one there in my time. Thank you for joining us, Professor, and the floor is yours.
Thank you, Mr. Chairman, Senator Leahy, members of the committee. Good morning, and thank you for the opportunity to testify today.
I should have added, Professor, that you clerked for Judge Alito after graduating from law school. I think that ought to be on the record. Start the clock back in 5 minutes.
I was about to add that. Thank you very much. Now, since the very early days of my clerkship, I must admit that Judge Alito has really become my role model. I do think that he's one of the most brilliant legal minds of our generation, or of his generation, and he's a man of great decency, integrity, and character. And I say all of this as what I would consider to be a left-leaning Democrat, a woman, obviously, a member of the ACLU, and an immigrant. And my view is not one that is unique with regard to people who have worked with him or with regard to people who have worked for Judge Alito. Now, all of his clerks, many of whom are politically liberal, have signed on to a letter strongly urging the Senate to confirm Judge Alito as Associate Justice. A number of non-Republican legal academics who have worked with or for Judge Alito have also issued an equally forceful statement on his behalf. Let me explain to you why I believe that Samuel Alito deserves to sit on the highest court, and why his confirmation will in fact not pose a threat to the rights of women, to the rights of minorities, immigrants, or other vulnerable groups. Now, Judge Alito does not have a political agenda. He gives very careful consideration to the lower court record and to prior judicial decisions. Now, let me point you to two cases that may explain the judge's philosophy. While I clerked for him, he had to decide the case of Paris Fatin. Ms. Fatin had left Iran in order, in part, to be escaping the regime of Ayatollah Khomeini. She applied for asylum in the United States, but was denied by the Immigration Court and by the Board of Immigration Appeals. Now, without revealing any confidences, I can tell you that Judge Alito was very much moved by the personal tragedy of the situation and the moral dilemma Ms. Fatin would face. If returned to Iran, she would either be unable to speak her deep feminist convictions or the Iranian regime would penalize her. Now, the problem with her case was that there was really an absence of favorable case law and, even worse, a very thin record that indicated only very limited opposition on her part to the Iranian regime. Now, the judge did not see himself in a position to help Ms. Fatin, who was, however, ultimately permitted to stay in the United States. He, however, did take this opportunity to write one of the most progressive opinions on gender-based asylum law. Now, his decision was the first to recognize that gender alone could constitute a basis for asylum. This revolution in asylum law has not been widely recognized outside a very small group of asylum practitioners. And neither has Judge Alito gotten a whole lot of credit for garnering the votes of both of his fellow panelists for this decision, one of whom was a Nixon appointee. Now, the Fatin case hasn't gotten a lot of attention, but you have spent part of the day yesterday on the Rybar case where Judge Alito dissented. Now, I think you should read the case a little differently than the way in which it has been portrayed. Now, let me just set the context. In 1995, the Supreme Court decided Lopez, Justice O'Connor joining the majority, striking down the possession of machine guns on school grounds as unconstitutional. Now, I think a lot of commentators expected this to create a major shift in lower court jurisprudence. This did not happen, I think in part because the lower courts read the decision extremely narrowly and arguably incorrectly. Now, Judge Alito, who has been, I think, generally labeled as an anti-criminal defendant judge, was very much willing to follow Supreme Court precedent to the point where it would necessitate the dismissal of a host of criminal indictments. At the same time, he took pains to note that Congress could very easily remedy the problem with the statute by indicating in the record that there was a connection between the possession of machine guns and interstate commerce. Now, let me also point you to the fact that a Blue Ribbon ABA task force has increasingly critiqued the increasing federalization of criminal law. Now, Judge Alito's record, I think, indicates, and Rybar confirms, that he will follow Supreme Court cases very carefully, and that he will read congressional legislation very carefully. He has also used, I think, his prior background experience very effectively in working, for example, on sentencing reform with the Constitution Project, and at one point as an advisory board member of the Federal Sentencing Reporter. I believe overall that his criminal background experience will inform the judge's decision, but it will surely not bias him in one way or the other. He'll be able to strike a practical balance that is informed but not predetermined by his background. And for all those reasons, I believe very strongly that he deserves to be confirmed as the court's next Associate Justice.
Thank you very much, Professor. We now turn to Professor Erwin Chemerinsky, the Alston and Byrd Professor of Law and Political Science at Duke. Prior to coming to Duke in 2004, he had been for 21 years at the University of Southern California Law School, where he was the Ermis Professor of Public Interest Law. He's a graduate of Northwestern University with a bachelor's degree and a law degree from Harvard. And last year, he was named by Legal Affairs as one of the top 20 legal thinkers in America. Thank you for coming in today, Professor, and the floor is yours.
Thank you, Mr. Chairman, Senator Lay, distinguished senators. It's truly an honor and a privilege to testify at these historic hearings. It's impossible to overstate the importance of this nomination for the future of constitutional law. In recent years, the Supreme Court has often referred to as the O'Connor Court because Senator O'Connor so often has been in the majority in 5-4 decisions in crucial areas, protecting reproductive freedom, enforcing the separation of church and state, limiting presidential power, and advancing racial justice. Replacing her has the possibility of dramatic changes in so many areas of constitutional law. A crucial question for this committee is what will be the effect of Samuel Alito on the Supreme Court? I want to focus on one area, executive power. I choose this area because no area of constitutional law is likely to be more important in the years ahead than this. As you know, in recent years, the Bush administration has made unprecedented claims of expansive presidential power, such as the claim of authority to detain American citizens as enemy combatants without meeting the Constitution's requirements for warrant, grand jury indictment, or trial by jury, the claim of authority to torture human beings in violation of international law, the claim of authority to eavesdrop on conversations of Americans without complying with the Fourth Amendment or the Foreign Intelligence Surveillance Act, the claim of authority to hold American citizens indefinitely and citizens of other countries indefinitely as enemy combatants. Now, my goal here isn't to discuss the merits of any of these issues. Instead, to point to the fact that separation of powers is likely an enormously important issue in the years ahead. And of course, there's no need to remind this body of the crucial role that checks and balance separation of powers play in our Constitution's structure. Some of the most important Supreme Court cases in history have been those where the Court has said no to assertions of presidential power, such as in Youngstown Sheet and Tube versus Sawyer, and striking down President Truman's seizure of the steel mills, in United States versus Nixon, and saying that President Nixon had to reveal the Watergate tapes. A key question for this committee is whether Samuel Alito will continue this tradition of enforcing checks and balances, or whether he'll be a rubber stamp for presidential power. I have carefully read the writings, the speeches, and the decisions of Samuel Alito in this area, and they all point in one direction, a very troubling pattern of great deference to executive authority. I've closely followed the hearings this week, and I know you're familiar with the examples. To mention just a few, in 1984, while in the Solicitor General's office, Samuel Alito wrote a memo saying that he believed that the Attorney General should have absolute immunity to civil suits for money damages if engaging in illegal wiretapping. A position the Supreme Court rejected, and language seems so appropriate now in saying there would be too great a danger of violation of rights from executive officials who, in the zeal to protect national security, would go too far. The next year, he said there should be increased use of presidential signing statements. He said, quote, the president should have the last word as to the meaning of statutes. There should be an increase in executive power. As you know, in a number of writings and speeches, he said he believed in the unitary executive theory. Now, there's a good deal of discussion this week as to what that means. But if you look at the literature of constitutional law, those who believe in a unitary executive truly want a radical change in American government. They believe that independent regulatory agencies like the Securities and Exchange Commission or the Federal Communication Commission are unconstitutional. They believe the special prosecutor is unconstitutional. They reject the ability of Congress to limit the executive. Now, as a judge on the Third Circuit, Judge Alito has not had the opportunity to review assertions of presidential power. But there have been many cases where he's considered assertions of law enforcement authority. Over and again, he comes down on the side of law enforcement. I think his dissenting opinions are particularly revealing because Judge Becker said he really dissents. One case, I think, shows Judge Alito's overall philosophy. It's one discussed yesterday at the end of the day, Doe versus Grudy. This, of course, was the case where the police strip searched a mother and her 10-year-old daughter who were suspected of no crime. As Carter Phillips said yesterday, this was an issue of qualified immunity. That means, did the officers violate clearly established law that a reasonable officer know? Should the officer have known that it violates the Constitution? Senators, any police officer, any judge should know that strip searching a 10-year-old girl who was suspected of nothing violated the Constitution. Senators, this is one of so many cases where Judge Alito deferred to law enforcement. I'm here for a simple reason. I believe that at this point in time, it's too dangerous to have a person like Samuel Alito with his writings and records on executive power on the United States Supreme Court. Thank you.
Thank you very much, Professor. We now turn to Professor Anthony Kroneman. After teaching at the University of Chicago Law School and Minnesota Law School, Professor Kroneman came to Yale, where he has been on the faculty for 16 years and was the dean of the law school from 1994 to the year 2004, and is a sterling professor of law at Yale. He has his undergraduate degree from Williams in 1968 with highest honors, a PhD in philosophy at Yale, a law degree from Yale in 1975 when he was a classmate of Judge Alito. Thank you for being with us today, Professor, and the floor is yours.
Thank you, Mr. Chairman. Senator Leahy, other members of the committee, I'm grateful for the opportunity to appear this morning and offer my testimony. I've known Sam Alito for 33 years, since we met in the fall of 1972 as members of the entering class at the Yale Law School. Over the next 3 years, we took nearly a third of our law school courses together. We worked on the Law Journal together. We debated in the moot court program. I had a chance to observe Sam Alito at close range and to form an estimate of his character. Sam was hardworking and ferociously bright. No one, I think, would challenge that. But that wasn't the first thing that impressed me about Sam. What impressed me first and most emphatically was his generosity and gentleness. When Sam spoke, in class or out, others listened. But when others spoke, Sam listened. And not just in the superficial sense of waiting politely until they had finished, but in the deeper and more consequential sense of straining to grasp the good sense of their position and to see it in its most attractive light. Sam always spoke with modesty, but even when he was defending a position that he believed clearly to be right, did so with the knowledge that he might be wrong. Learned Hand once described the spirit of liberty as the spirit that's not too sure of itself. That's a phrase that's always had a special meaning for me, and it well describes the quality in Sam that I noticed from the start. I noticed something else and admired something else as well, and that was Sam's faith in the law. Sam believed in the integrity of the law and in the essential fairness of its processes. Anyone who has studied the law knows that it is not a mechanical system. It requires moral judgments at many points. But there is all the difference in the world between a person who approaches the law from the outside and views it as an instrument for the advancement of some program of one kind or another, and a person who approaches it from the inside and whose fundamental leading allegiance is to the law itself. Sam falls clearly in that second category. He had, so far as I could tell, no political agenda of any kind. I would have described him in law school as a lawyer's lawyer, and if you had asked me on the day we graduated whether he was a Democrat, as I was then and am today, or a Republican, I couldn't have told you. My knowledge of Sam Alito is based almost entirely on my personal acquaintance with the man, but since his nomination to the Supreme Court, I have attempted, as have many others, to glean at least a sense of his judicial temperament by reading a few of his opinions. I haven't read many. I haven't made a systematic study of them, but the ones that I have read suggest to me rather strongly that the judicial temperament that I discern in these opinions is entirely consistent with the human temperament of the man I came to know and admire more than 30 years ago. The temperament of the judge, as I see it, is marked by modesty, by caution, by deference to others in different roles with different responsibilities, by an acute appreciation of the limitations of his own office, and by a deep and abiding respect for the past. There is a name that we give to all of these qualities taken together. We call them judiciousness. And in calling them that, we recognize that they are the special virtues of a judge. Judge Alito has been a judicious judge, and my confidence that he will be a judicious justice is based on my personal knowledge of the man and my belief that his judicial temperament is rooted in his human character, which is the deepest and strongest foundation it could have. Thank you very much.
Thank you very much, Professor Croneman. We turn now to Ms. Beth Nolan, partner in Crowell and Mooring's litigation group, has a broad practice which focuses on constitutional and public policy issues. Ms. Nolan held prestigious and high-ranking positions in the Clinton administration and the Department of Justice and the Office of Legal Counsel. She had been a clerk to the Chief Judge Colin Seitz of the Third Circuit, is an undergraduate, has an undergraduate degree from Scripps College and a law degree magna cum laude from Georgetown in 1980. Thank you for being with us today, Ms. Nolan, and we look forward to your testimony.
Thank you, Mr. Chairman. Senator Leahy, members of the committee, I'm delighted to be here today, and thank you for inviting me to provide my views. I want to address one issue, how Judge Alito, if he should become Justice Alito, would approach questions of executive power. I've served, as you mentioned, Mr. Chairman, in the White House as counsel to the President, in political and career positions in the Office of Legal Counsel in the Clinton and Reagan administrations. And as might be expected of one who has served as legal counsel to the President, I believe it is essential to defend the power of the President to undertake his constitutionally assigned responsibilities and to resist illegitimate incursions on that power. And certainly in my position as White House counsel, I sometimes was in conflict with Congress as each branch struggled to assert its views of its authority. This does not mean, however, that the executive should assert a view of its power that is virtually unconstrained or that fails to take account of the constitutional powers of Congress. Presidential power should be interpreted, even by lawyers for the President, with proper respect for the coordinate branches, not solely to maximize presidential power. Judge Alito's service, as has been mentioned, on the Third Circuit has not offered him much opportunity to address issues of executive power, but we do have some indication of his views. And I find particularly instructive and troubling his 2000 Federalist Society remarks in which he announced his support of the unitary executive theory. What he means by that support is a critical question. It's a small phrase in one way, unitary executive, but it has almost limitless import to many of its adherents. At one level, it embodies the concept of presidential control over all executive functions, as Professor Chemerinsky mentioned, a concept that's been soundly rejected by the Supreme Court. But the phrase also often serves to embrace a bundle of expansive interpretations of the president's substantive powers and correspondingly stringent limits on the legislative and judicial branches. This is the apparent meaning of the phrase in many of the this administration's signing statements claiming broad powers for the president. In his Federalist Society speech, Judge Alito endorsed the theory of the unitary executive as developed during the period he served in the Office of Legal Counsel as a supervising deputy. An important question is how he views OLC precedents from that time. In one opinion from that time involving covert activities, OLC expressed the President's authority in sweeping terms, adopting Justice Sutherland's dicta from a very different context to assert that the President's authority to act in the field of international relations is plenary, exclusive, and subject to no legal limitations save those derived from the applicable provisions of the Constitution itself, while declaring that Congress had only those powers in the area of foreign affairs that directly involve the exercise of legal authority over U.S. citizens. This would seem to mean that the President is essentially above the law in the areas of foreign affairs, national security, and war, and Congress is powerless to act as a constraint against presidential overreaching in these areas. It is a fair question whether Judge Alito agrees with these sweeping views. This is not just of historical interest, of course. That version of unitary executives from the 1980s sounds remarkably similar to the assertions of unreviewable and unconstrained powers the current president has asserted with regard to his authority to ignore the laws passed by Congress, such as those forbidding torture and those regulating electronic surveillance. These issues may well come before the Supreme Court. Judge Alito indicated over 20 years ago his strenuous disagreement with the usurpation by the judiciary of the decision-making authority of the political branches. Does this signal that he will defer to the executive branch's positions on its power and its claims that these positions are largely unreviewable? Or will he, as Justice O'Connor did in Hamdi, see a clear role for the courts in protecting our constitutional balance and hence our civil liberties? Judge Alito's statements about executive power raise legitimate and serious questions that should be explored.
Thank you very much, Ms. Nolan. Our next witness is Professor Charles Freed of the Harvard Law School, an expert in the areas of constitutional, legal, and moral philosophy. From 1985 to 1989, he was Solicitor General of the United States, and from 1995 through 1999, he was an Associate Justice of the Supreme Judicial Council of Massachusetts. He holds a bachelor's degree from Princeton, a doctor of law from Columbia, and both bachelor's and master's from Oxford University. Professor Freed, in his capacity as Solicitor General, was Judge Alito's superior when Judge Alito worked in that office. Thank you for joining us, Professor Freed, and we look forward to your testimony.
Thank you, Chairman Spector, and I thank the members of the committee for inviting me. I think what I can most usefully do is cast some light on Judge Alito's, and if I slip into Sam, please forgive me because we were a small and very collegially and friendly office, Judge Alito's work in that office. The Reagan administration, no doubt, had a point of view about the law, just as did the FDR administration in 1933 or the JFK administration in 1961. That is not unusual. That's what elections are about. Part of that view encompassed the notion that the lower courts had gone too far in limiting the ability of law enforcement, that the lower courts had moved too far away from an appropriate view of affirmative action as expressed by Justice Powell in Bakke towards quotas, and I suppose emblematic of the notion that courts sometimes just make things up was the notion that Roe v. Wade was incorrectly decided, a notion which, may I say, was shared by people across the political spectrum Professor Paul Freund, Archibald Cox expressed that view as late as 1985, D. Neely. Now, the first job of the staff of the Solicitor General's office was to make sure that when the Solicitor General presented the Solicitor General's client's position to the Supreme Court, this was done in a professional, correct, and respectful way. That office had career lawyers, some of whom stretched back to the time of Lyndon Johnson. I myself appointed as deputies people who I knew to be Democrats, liberal Democrats. None of that bothered me or bothered them, because we were a professional office and they understood that their work was professional work. That is exactly how Judge Alito viewed his work. If I look at the example that has, two examples that have been much featured in these discussions, his memo to me in the Thornburg case on Roe v. Wade, it is said that he argued that Roe v. Wade should be overruled. He did not. You need only read that memo, because he said in that memo that we should not argue that Roe v. Wade should be overruled. I didn't follow that advice, but that was what the advice was. Similarly, it is said that he argued for the absolute immunity of the Attorney General in connection with wiretaps. He did not. What he said was, I don't question that immunity, but we should not propose that argument. We should not make that argument to the court. Now, in 1985, he wanted a job in the administration, and at that point, he took on a different role, and he spoke in a different tone of voice. I think that's perfectly understandable and appropriate. And when 15 years later, he became a judge, 15 years ago he became a judge, he once again assumed a different role. His whole career shows that he understands the difference between a professional lawyer, an advocate, and a judge. And no more eloquent testimony of that understanding can be had than the wonderful testimony of his colleagues, Democrat and Republican, liberal and conservative, who served with him for those 15 years. I believe that it's perfectly appropriate for this panel, for this committee, to have probed Judge Alito's disposition. Everybody has a disposition. He is in the mainstream. He tends towards the right bank of the mainstream. I agree. When this Senate approved two wonderful judges to be justices, Justice Breyer and Justice Ginsburg, it was perfectly plain that they tended towards the left bank of the mainstream. And they were confirmed, and properly so. I believe Judge Alito should be as well.
Thank you very much, Professor Freed. Our next witness is Professor Lawrence Tribe, Loeb University professor at the Harvard University and professor of constitutional law at the Harvard Law School. Professor Tribe has argued before the United States Supreme Court over 33 times, served as a law clerk to Justice Potter Stewart, received his bachelor's degree from Harvard College, summa cum laude, in 1962, and a law degree also from Harvard, magna cum laude, in 1966. Professor Tribe, the floor is yours.
Thank you very much, Mr. Chairman, Senator Leahy, members of the committee. It's a great honor to be here on this very important occasion. I'm not here to endorse the nomination of Judge Alito, as I did with my most recent testimony before this committee on a Supreme Court nomination with Justice Kennedy. I'm not here to oppose his nomination, as I did several months before that time with Robert Bork. And I'm not here to lecture the committee on its responsibilities or its role. I don't think that's my role. I think the only useful function that I can perform is to ensure, to the limited extent I can, that senators not cast their votes with, to borrow an image from a Kubrick movie, their eyes wide shut. It is quite clear that there are two central concerns in the country and in the Senate with respect to this nomination. And they do not relate, honestly, to what a truly admirable, collegial, modest, thoughtful, and brilliant fellow Sam Alito is. And I don't mean to call him Sam. I don't really know him the way that my colleague Charles does. They relate to whether Justice Alito might, by casting a decisive fifth vote on many cases, narrow the scope of personal liberty, especially for women, and broaden the scope of presidential power at a time when we see dramatically the dangers of an unfettered executive by weakening the ability of both Congress and the courts to restrict presidential assertions of authority. A word first about liberty. It is certainly true that in the Solicitor General's office, the memorandum that Judge Alito wrote for the Solicitor General did not urge that the court be confronted frontally, overrule Roe. But he made it clear even then that the strategy he thought wise to pursue was a step-by-step process toward the ultimate goal of overruling Roe. And that is the only prospect on the table. I assure you that if the Supreme Court actually overrules Roe, I will have thousands of students to tell that I predicted the wrong thing. That's not the danger. They won't say Roe v. Wade is hereby overruled. What they will do, and I'm saying will because I am assuming that confirmation will occur. Maybe it won't. But with the vote of Judge Alito as Justice Alito, the court will cut back on Roe v. Wade, step by step, not just to the point where, as the moderate American center has it, abortion is cautiously restricted, but to the point where the fundamental underlying right to liberty becomes a hollow shell. It is the liberty interest, which occurs not only in Roe, but in the right to die and in many cases that we can't predict over the next century, and certainly over the 30 years that Justice Alito would serve. It is that underlying liberty which is at stake, and it is crucial to know that Judge Alito dramatically misstated the current state of the law. And I say that with deference and respect, but it was clear. When pushed on whether he still believed, as he said, not in his role as a government lawyer, but in his personal capacity, that he believed the Constitution does not protect a right to abortion, when he was asked, do you still believe that? He said, well, I would approach it by starting with Casey. Casey, in 1992, he said, began and ended with precedent, stare decisis. Casey simply followed Roe, and he thereby avoided the issue. That's not true. Casey split the baby in half. That is, Casey said there are two fundamental questions here. One, does the woman have a fundamental liberty at stake when she's pregnant and she wants to make a decision? And number two, assuming she does, at what point does the state's interest in the fetus trump the woman's liberty? On the liberty issue, the court did not rely on stare decisis and Roe. The moderate justices who wrote the joint opinion, Justices O'Connor and Kennedy and Souter, said that on the underlying issue of liberty, we agree clearly the woman's liberty is important, special, not just like the right to fix prices. Because if we didn't think that, and if we had a case where a teenage girl is being forced to have an abortion, her liberty wouldn't be special either. And therefore, we must conclude, without relying on Roe, this is a liberty deserving of special protection. Never in the descriptions that you heard from Judge Alito with respect to the issues in Roe did he confront the question, does he too believe that that liberty is special? Or does he, as did Robert Bork and as do many, believe that there is no special liberty simply because the woman happens to have a fetus inside? Her interest is no greater than my interest in learning how to play tennis. So it seems to me clear that the indications we have of Judge Alito's belief are that he does not have a conviction that that liberty is special, and he is unwilling not only to commit to treating this as a so-called super precedent, he's not even willing to indicate to this committee that he believes that the court has a special role in protecting intimate personal liberties. Now, with respect to consolidating the powers of the president, I want to associate myself completely with the remarks of Beth Nolan. It is very clear that with respect to the unitary executive theory that is being espoused, that what you saw in the instance of Judge Alito's testimony was not a forthright description of what he said he believed.
Professor Tribe, you're a minute and a half over. If you could summarize,
I'm sorry.
we'd appreciate it.
I will certainly summarize. When he spoke in November of 2000, after Morrison was decided, he outlined a strategy for consolidating the power of the president, notwithstanding Morrison, and I think it is easy to explain, but I won't try to do it over time, why the distinction he tried to draw between the president's control of functions within his power and the scope of executive power is a completely phony distinction.
Professor Tribe, did you say you were not testifying against Judge Alito?
I'm not recommending any action. I'm recommending that everyone, because I think it's foolish. Nobody really cares what I think.
Aside from your recommendation, are you saying you're not testifying against Judge Alito?
I'm not testifying for or against Judge Alito. I'm explaining why I'm very troubled by his views. Obviously, it follows from that that I would be hard-pressed to recommend his confirmation.
The clock needs to start at 5 minutes, even for the chairman, for everybody. Well, now, I'd already started the 5-minute round, but we'll proceed, and as we all know, after the panel testifies, each senator has 5 minutes of questioning. Professor Freed, you testified in the confirmation hearing of Chief Justice Roberts that you thought Roe was wrongly decided, but you also thought that Roe should not be overruled. And that's based on the reliance and upon the precedents and upon stare decisis. You've worked closely with Judge Alito. I know you've followed his career. What is your sense as to how Judge Alito will approach the Roe issue if it should come before the court for reversal or being sustained in the context of your understanding of his approach to stare decisis?
Well, I think it's a version, but only a version, of what my colleague and friend Larry Tribe has said. I think he will not, and Larry agrees with that, move towards a frontal overruling, just as he has been urged and others have urged should happen. That's my belief, and I could be quite wrong. I could be quite wrong about that, but that's my belief. Now, the idea that he would chip away at it, I'm not sure I know what that means. When the Casey decision came down and Justice O'Connor, and it's clearly Justice O'Connor, moved from the very strict, almost abortion-on-demand standards of Roe towards the undue burden standard, a cry went up from the community, which I think Professor Tribe is associated with, that this was a disaster. But in fact, it was a reasonable thing to do. And we do not know what the future holds. But I don't expect him to do things which would be other than in the reasonable tradition of Casey, which I agree with Professor Tribe is a much better decision and a much better founded decision than Roe.
Ms. Nolan, the critical issue which the Congress is going to be looking at, and this committee is going to hold a hearing on, is the president's power on eavesdropping without a warrant in contravention of the specific provision of the Foreign Intelligence Surveillance Act. during the Clinton administration, Deputy Attorney General Jamie Gorelick testified, I see you nodding, you know, she testified that the president had inherent authority to conduct those warrantless searches. What have you seen aside from the generalizations of unitary power? Anything specific in the record of Judge Alito that he has a view on that critical issue?
First of all, I just want to be clear that Deputy Attorney General Gorelick's testimony was about inherent authority in the absence of a statutory provision. It was physical searches not covered by FISA. So just to clarify that.
She testified during the Clinton administration, which was long after FISA was adopted.
Yes, but it didn't cover physical searches, and that was the question at that time. It was part of the Ames case. And in fact, the administration brought to Congress a request that FISA be amended to cover physical searches.
Okay, on to Judge Alito.
I'm not aware of anything in Judge Alito. I'm not aware of anything in Judge Alito's record with regard to that.
Professor Chemerinsky, do you think you commented that the issue is to Judge Alito as to whether he'd be a rubber stamp or not for executive power? You think he'd be a rubber stamp?
Everything that I could find in his record points to tremendous deference to executive authority.
Well, tremendous deference is a little different from being a rubber stamp.
I think the key question that this committee has to face is, will this be a justice who, when these issues that we're talking about come before the court, be willing to enforce checks and balances? In light of his entire career before going to the bench being the executive branch, in light of his writings when he was in the Solicitor General's office, the speeches that he's given, the opinions he's written on the Third Circuit, I don't find anything to indicate that he will be enforcing checks and balances.
So you think he'd be a rubber stamp?
I think the record here does speak for itself. I think if we can't find anything that points to a willingness to enforce checks and balances.
I want to ask a question of Professor Cronin and Professor Leitner. Been a lot of talk about Judge Alito, whether he is deferential to the powerful and to the government. You, Professor Leitner, was his clerk. You know him pretty well. You know him, Professor Cronin, for several decades. I'd like you to address your sense of him on that issue. Start with you, Professor Leitner.
I have never seen anything while I clerked for him or in subsequent years that led me to believe that he had an agenda or any kind of plan to favor particular groups over others. He really, in my experience, looks at each case individually, and I'm sure he was surprised when he saw the statistics adding up how often he voted for a corporation or for an individual. Quite to the contrary, I think his opening statement was a very powerful one in which he addressed his own background, and I think it indicates that he would not be inclined to favor big government or big corporate interests over individual interests.
Professor Cronin?
I would agree with that. I have no reason to think that Judge Alito begins with a strong dispositional inclination to always favor governmental power over individual rights. He does, I think, have an inclination to be respectful of those in positions of institutional authority who have wrestled with questions that come before his court, and to take seriously the thought they've given to those questions, and to weigh them appropriately.
Thank you very much, Senator Leahy.
Thank you, Mr. Chairman. I'm curious, and I listened very carefully, Professor Chemerinsky. Did I pronounce that correctly?
Yes, you did. Thank you.
Thank you. In 2004, in the Hyundai case, and I'm sure you're very familiar with that, the Supreme Court considered whether due process required that a citizen of this country was being held as an enemy combatant, but a citizen of this country should be afforded a meaningful opportunity to challenge the factual basis for the detention. The Justice O'Connor's decision for the court upheld the fundamental principle of judicial review over the executive authority. She said, in effect, that even if you have war, whether declared war or war on terror, whatever, it's not a blank check for the president when it comes to the rights of nation citizens. Now, the unitary executive theory, which Judge Alito espoused in remarks just as recently as 5 years ago, was championed in dissent by Justice Thomas in Hamdi, and saying that the war powers of the president couldn't be balanced away by the court. Well, I'm going to ask you this, and then I'll ask Ms. Nolan the same question. What are the implications for the rights of Americans to be free from governmental intrusions were Justice Thomas's views to prevail rather than Justice O'Connor's?
It's an enormously important question. Hamdi was a tremendous victory for all American citizens because, as you say, the Supreme Court said that before an American citizen can be held as a combatant, there must be due process, notice of the charges, an opportunity to be heard, representation by counsel. There was only one dissent directly to that, and that was Justice Thomas, who advances the unitary executive theory as the reason why the president should be able to hold individuals without due process. You ask, well, what might be the implications of this? Well, the question would be, can the president engage in electronic eavesdropping in violation of the Foreign Intelligence Surveillance Act? It seems clear what the unitary executive theory would say about that. Can the president hold an American citizen as an enemy combatant without a warrant for arrest, a grand jury indictment, or a jury trial? I can think of nothing more antithetical to the Constitution, but the unitary executive theory would seem to say yes.
Well, and Ms. Nolan, what would you say about that? And add to the professor added this question of wiretapping outside the Foreign Intelligence Surveillance Act. If you could go to my original question, but also tell me, what would you have given as advice the President of the United States if he said, I'm going to bypass FISA, I'm just going to go wiretap on my own innate authority?
Well, here I'm going to show my credentials as a lawyer to the president and say that I'm not exactly sure because we don't know the full contours of the program. So I want to be clear that it's possible that the president could bring something to me that would make me say, under these circumstances,
Let's go
emergency powers.
by what you've seen in the
But
press.
what I've seen, I would say you have to follow FISA or you have to go to Congress and get it amended.
And do you agree with Professor Chemerinsky that under the unitary form of government, we'd be in a much different world if that had prevailed in the Supreme Court rather than Justice O'Connor's view on Hamdi?
Absolutely, and I think the electronic surveillance is a perfect example of this theory going to the next step, which is it's based on this unitary executive theory and the commander-in-chief power, but the theater of war now is the entire world, including the United States. And the end of the war may be never when we're talking about the war on terror. And so we're not talking about limited emergency presidential powers in a very short period of time.
We're talking about powers being used for the rest of my lifetime and your lifetime.
That's correct.
Well, and if I might, because the time is limited, and I'd like to pursue that because I think you're absolutely right. If we say it's a war on terror, nations that face terrorist threats throughout their history. Look at Europe. Look at other countries. Do we set aside our Constitution on the claim that we may face these? But Professor Tribe and you and I have talked about a number of issues over the years, and I appreciate all the help you've given both me and this committee. I think about last month, we passed the McCain Amendment that prohibited inhuman, degrading treatment of detainees by U.S. personnel under all circumstances. Originally strongly opposed by the administration. Their polling, the White House polling and published polling showed not a position sustainable. They worked out a deal with Senator McCain, the president. Great fanfare, signed this, of course, then very quietly issued a statement, in effect, construing what the law was and exempting or carving out exemption for the executive. Now, let's say there was a violation brought before the courts the McCain Amendment prohibiting cruel, inhuman, and degrading conduct, and it came before a court. What weight would a court give? Would the court give an equal weight to the statute overwhelmingly passed by Congress, signed into law by the President? Would they give equal weight to that as they would to this signing statement, which carved out exceptions to the law signed by the President?
Senator, under current law, a clear majority of the Supreme Court and most circuit courts would say that although in cases of ambiguity, the understanding of the President of the law's meaning at the time it's signed might be a factor to consider, when, as in this case, the law was clear, or as clear as one can be in talking about gradations of methods of interrogation, that the McCain law, the statute, and the Levin-Graham compromise, or whichever way it was sequenced, is the law. And the statement made by the President of the United States on December 30 of 2005, that this will be enforced by the President only in accord with his power over the unitary executive, a phrase that is constantly used by this administration, and when that was understood to mean that he will decide in his unfettered discretion when the method of interrogation crosses the McCain line and is cruel and inhumane, that would be given no weight. But there is no way consistent with his expressed beliefs that a Justice Alito could go along with that view. That is, under his view, which would be, I think, quite similar to the view of Justice Thomas dissenting in Hamdi, it is up to the President to decide how he will, through his subordinates in the unitary executive branch, carry out his authority as Commander-in-Chief, especially given the authorization for the use of military force. And it is interesting that when asked by Senator Durbin about the role of the unitary executive theory in Hamdi, which goes directly to the question whether American citizens could be detained indefinitely or made subject to eavesdropping under the broad authority of the authorization for the use of military force, notwithstanding FISA, he said, well, I'm not sure that Justice Thomas referred to the unitary executive theory. Well, in fact, he did. Just read his opinion. He relies heavily on, and names, he says, because the unitary executive must have discretion to decide how to carry out the war, it is his views that will prevail. But it would not be on the theory that the President's understanding of the law trumps Congress's intent. It would rather be on the theory that the President has unfettered power to control the entire executive branch within the reach of his authority. Now, let me, if I might just say why this distinction between scope, the reach of his authority, and control is not a coherent one. Yes, it is true that the unitary executive theory would not suddenly add to the executive branch a distinct lump of lawmaking powers. For example, the power that Truman exercised in the steel crisis. The President couldn't suddenly, under the unitary executive theory, gain the power of eminent domain. But the President does have the power to disregard acts of Congress that would impinge on his carrying out of an executive function. And under the views that were expressed by Judge Alito in his testimony, and the views that were really the underpinning of the unitary executive theory when it was cooked up in a creative storm in the Office of Legal Counsel in the period when Judge Alito was there, the underpinnings include the notion that the President has inherent power over foreign affairs,
Professor Tribe, we're way over time on this section. If you could wrap up that answer.
It's wrapped
I
up.
want to be deferential to Senator Leahy, who has a follow-up. This is not a precedent now. Go ahead.
No, that's okay. This was actually my follow-up was going to go into this subject, so I was interested in the answer.
Okay, if you're sure. Senator Hatch?
Thank you. Thank you very much, Professor Tribe.
Well, I have to apologize to this brilliant panel because I wasn't here. I was down at the Blair House with the Chancellor of Germany that I needed to do, and I have respect for all of you, and I just have one question. Maybe, Professor Fried, you could assist me with this. Could you please, we've had some difference of opinion as to what settled law is in this body. The common question asked is, do you believe Roe versus Wade is settled law, or any number of other opinions as well? Mr. Fried, could you explain the difference between settled law and settled precedent? Because as I heard both of the, as I heard both Chief Justice Roberts, now Chief Justice Roberts, and Sam Alito, Judge Alito, they basically both said that they believe that Roe versus Wade and a number of other cases are settled precedents. Now, I think what I'd like you to do is, could you please explain the terms settled law and settled precedent, so that we all understand it once and for all, and whether the two witnesses, now Chief Justice Roberts when he was Judge Roberts, and Judge Alito, whether they were consistent in their answers on that particular issue.
I'm afraid I'm unable to say what the difference between settled law and settled precedent is. I think that came out during the very excellent questioning by Senator Feinstein. And Judge Alito's answers, I think, were admirable. Chief Justice Roberts answered Senator Feinstein and came up with the statement of settled law, settled precedent. I don't think that that there was an attempt to make some distinction between those two concepts. But what he was suggesting is that this is something that is so well understood that it would be really extremely disruptive and unfortunately disruptive to overrule it. Now, Judge Alito, this was taken by members of this body and in the press as an absolute commitment how Judge Roberts would vote. I don't believe he meant it as that. And Judge Alito, to his credit, when he was asked that question, was so scrupulous about giving a commitment, which he absolutely must not do, and which I don't think any member of this panel would want him to do, to make a commitment, that he avoided a formulation which had come to be made the equivalent of a commitment, of an oath that I shall never do that. No judge, no person who aspires to be on a court should ever make a commitment about how he or she will vote. I think you all agree with that. And I think Judge Alito, though it is causing trouble for him and will cause trouble for him, was unwilling to enter that territory because of his very admirable scrupulousness.
Well, thank you, Mr. Chairman. I just wanted to clarify that. I think that does clarify that, and because that's the way I interpreted it as well. But thank you for answering that.
Thank you, Senator Hatch. Senator Kennedy.
Thank you very much, Mr. Chairman. To come back to this unitary presidency or executive, Judge Alito was asked frequently about his view about this and also about its impact upon the administrative agencies. And he responded during the course of the hearings that the Humphrey executor to Morrison upheld the powers of Congress to create the independent agencies and try to leave it at that. Of course, what's enormously interesting was his statement that his dissent in the Morrison case, where he took exception to the Morrison, that he says, but perhaps the Morrison decision can be read in a way that heeds, if not the constitutional text that I mentioned, at least the objectives for setting up a unitary executive that could lead to a fairly strong degree of presidential control over the work of the administration agencies in the areas of policy making. So this is his view. We appreciated understanding what the law is, and I think Professor Tribe indicated what he thought would be the decision, but this is his view. And then in his work at the Justice Department at OLC on signing statements, and I'll include the appropriate paragraph, but let me just, in the issue of time, mention his statement here. Since the President's approval is just as important as that of the House or Senate, it seems to follow that the President's understanding of the bill should be just as important as that of Congress. It's rather, at least for me, I think for most legislators, a bizarre concept. I thought we were the legislative branch. But then he continues, from the perspective of the executive branch, the issuance of the interpretive signing statements would have two chief advantages. First, it would increase the power of the executive to shape the law. Increase the power of the executive to shape the law. And second, by forcing some rethinking by courts, scholars, and litigants, it may help to curb the prevalent abuses of legislative history. The question is, are we talking about someone that has a different understanding of the balance between the executive and the Congress and the judiciary in terms of the makings of law? It seems to me that this is an attempt to tip to change that balance and tip it more towards the executive at a time when we have certainly the challenges that are out here before the country to make it a fairer, more equitable, to deal with the problems and challenges that we're facing in the country in terms of opportunity. Professor Traub.
Well, I think I would underscore one aspect of what you were quoting, Senator Kennedy. Those statements that were made by Judge Alito about how he understands and how he believes one could shape the relationship among the branches of government after Morrison, which was the decision upholding the validity of the independent counsel law and the decision rejecting Congress's rejecting the attack on Congress's role with respect to the executive. When Judge Alito made those statements, he was not working for the government. He was not speaking in some other role. He was a judge. He had been a judge of the United States Court of Appeals for the Third Circuit for about 10 years. The statement was made on November 17, 2000, to a gathering of the Federalist Society, obviously a group exercising considerable influence with what was then the likely new administration. That was 10 days after the votes were counted in the election of 2000. It was 10 days after now President Bush had declared victory, even though the recounts were going on. So he was speaking to the decision makers who would perhaps decide, and he was already discussed as a possible nominee to the Supreme Court, who would decide whether he would remain on the Third Circuit. And he was saying to that group, I still believe in what we were arguing back in 1986 in OLC. He talks about the gospel according to OLC. He says, I still believe in that gospel. He's speaking as a judge. And he says, under that gospel, we have a way of giving the president more power. I cannot imagine more direct evidence of where
I'm sorry to interrupt you, but I have very brief time. Just how would that change the relationship between the executive and Congress?
It would make it much harder for Congress to say, you cannot interfere with the SEC in the following way. You can't override the directives of the Fed. Even the independence of the Federal Reserve Board, which could be distinguished on grounds that historically monetary control was outside the executive power, but that's a shaky ground when you believe in the full unitary executive. In theory, it could take over the conduct of all of the agencies because there are only three branches of government and they belong in the executive.
My time is up, Mr. Chairman.
Thank you, Senator Kennedy. The committee is going to break very briefly for the memorial service for David Rosenbaum, which is being held at 10:30 in this building. I want a number of members of the committee have expressed an interest in going there. I do not intend to stay for the full ceremony and will be back, and others may stay longer. But I just wanted to point that out, and we'll be breaking at about 10:20 or so. Now, Senator Sessions.
Mr. Chairman, could I just ask unanimous consent, put the place in the record several news articles and regarding this whole issue?
Without objection, they will be made a part of the record. Senator Sessions.
Professor Demleitner, I found your comments insightful, and from your perspective, as you said, a left-leaning Democrat, an ACLU member, and who worked at the Criminal Justice Clinic while you were at Yale, and you told a story about being with Judge Alito as his clerk, and you saw something that concerned you in an opinion, and you asked him about it, and he took the transcript home that night to read it. Would you share briefly how that came about and what that meant to you as a young law clerk?
Of course, I'd be happy to. Thank you for asking, Senator. Excuse me. I think it was in the fall of my clerkship, and as you said correctly, I had worked in the prison clinic at Yale, and obviously it was representing prison inmates, and so I had a very pro-defense outlook, which I think I still have today. And so clerking for a former federal prosecutor was somewhat, I guess, I was somewhat apprehensive about that. But from the very first day on, I think Judge Alito made it very clear that he wanted to hear all kinds of arguments. And I was, I think, generally inclined to argue to him that he should vote to reverse convictions. And there was one particular case that I remember very distinctly. It was a bribery case, and I had read the record, I had read the lower court transcript, and I thought there was some reason why he should vote to reverse. And, you know, a lot of, I think, other judges would have said, now I don't see it, and just left it at that. He took the entire lower court record home, took my memo home, and the next morning when he came back, it was very clear he had spent quite a bit of time with it. He had read it, he had digested it. He sat me down, he explained to me why I was wrong. He was right. But I was so impressed with it because he didn't just laugh, you know, this is one of Nora's other theories to set someone free, but he really took it seriously, and he did this with every single case. And so I actually wanted to respectfully disagree with Professor Tribe on this issue because I think collegiality, brilliance, listening to others, which Professor Kronman had talked about, are very important on a court that consists of only 9 members. Because I think it shows he will be open-minded, he will listen, he always listens, and I think that's very important, and he can be moved. I mean, I remember writing memos to him and discussing cases with him where I thought this is his position, and he came out of oral argument, and came out of the bench meeting with the judges afterwards, and he had changed his mind. So he's not set, he's not doctrinaire, and I think that's important to know about him.
Well, that's consistent with what his colleagues on the bench have said, that's for sure. And you mentioned the Rybar case. I agree with you on that. In fact, in that case, he ruled for the little guy against the prosecutors and the government who wanted to put the man in jail. He threw out the conviction. People have forgotten that in the course of the discussions. Ms. Nolan, I remember you served as legal counsel and the opportunities that we had to chat, and you point out that you believe it's essential to defend the power of the president to undertake his constitutional assigned responsibilities, whether considering the exercise of his powers under the Appointments Clause or under the Commander-in-Chief Clause. You had to do that in that position in the Department of Justice. You note that, in my view, the executive branch is right to resist inappropriate incursions on its power from the legislative and judicial branches, and we should thus expect that executive branch lawyers will strongly defend executive powers. Just briefly, before we get into some of my questions, Congress is never reluctant to expand its power and oftentimes to diminish executive power, and there's a constant tension there, is it not? From your perspective, you served under President Clinton.
There's definitely a tension. I do think Congress is sometimes reluctant, but there's definitely a tension.
Where's the funeral being?
Professor Freed, most of us, I think, are not familiar with this idea of unitary executive. I have heard it complained for many years, and I assume this is the genesis of it, that these ABC agencies, these alphabetical entities that are quasi a part of the executive branch, but nobody controls them, is somehow contrary to our three branches of government concept. And you've served in the Department of Justice, you've been Solicitor General, you've now a professor of law. Could you share us the tensions that might exist and how we might think about these issues?
I'd be glad to, but only if the chairman will give me the time.
Professor Freed, to the extent you can, would you make it brief? Because
I have a talent for making things brief. Yes, first of all, Morrison v. Olson, the independent counsel case, was the crucial case on the unitary executive, and it was my bitter experience to have argued that case and lost it 7-1. I always tell my class that if that had come up later and had been styled Clinton against Starr, I would have won it. Because by then it became perfectly obvious what an abomination that independent counsel law was, how it had been misused, and how it tore the fabric of our constitutional system. I think what has been said about the unitary executive in these hearings is very misleading. The unitary executive says nothing at all, nothing about whether the president must obey the law. It talks about the president's power to control the executive branch. That is the subject. And in this, the unitary executive theory is not an invention of the Reagan Justice Department or the Office of Legal Counsel. It was propounded in the first administration of Franklin Delano Roosevelt, who objected to the powers of the Comptroller General, who tried to fire a Federal Trade Commissioner, and who referred to himself as the general manager of the executive branch. That's the origin of the notion in FDR's administration.
thank you very much, Professor Freed, and thank you, Senator Sessions. I had asked you to be brief because Senator Feinstein wants to question before our break, and that is imminent. Senator Feinstein?
Thank you very much. I'd like to quickly go down the line and ask each witness which present or past justice do you think Judge Alito will most be like? Please, if you don't, Dr. Chemerinsky will come back. Do you have a view?
Sure. Your Honor, having read over 200 opinions written by Judge Alito, I think ideologically he is closest on the current court to Justice Scalia, which of course exactly what President Bush said he wanted in appointing a justice to the court.
I would name Justice John Harlan, who Judge Alito identified as one of his 4 heroes on the Supreme Court.
I think it's likely to be Justice Scalia, although I think he may be more aggressive on executive power than Justice Scalia has been in all areas.
It's certainly not Justice Scalia, because he has not sworn allegiance to any of the theology which Justice Scalia has propounded, never on any occasion. I think it's Robert Jackson.
I only wish it were Jackson or Harlan. I think he would be, I don't know that I accept the question as being sort of directly
You don't have to
but,
answer if you don't have a
well,
view.
but I wouldn't mind answering. I mean, I think he's somewhere between Scalia and Thomas, and I could explain the differences, but I don't think he's anything like Jackson or Harlan.
Thank you. Mr. Freed, I listened to your testimony on Justice Roberts with great interest. In a dialogue you had with Senator Specter, I want to quote what you said. You said, it is not only, talking about Roe, it is not only that it's been reaffirmed as to abortion, but that it has ramified It has struck roots. So it has been cited and used in the Lawrence case, in some of the opinions in the right to die cases, in the Troxel case, which is the grandparent visiting right case. So it's not only that it's there and it's a big tree, but it is ramified and exfoliated, and it would be an enormous disruption. So you not only get branches, you get leaves. And then you went on to say, since I don't know Judge Roberts except most casually, and I certainly have never discussed it, if you want a prediction from me, I would predict that he would never vote. No, not never, but he would not vote to overrule it for the reasons that I have given. Would you make the same prediction about Judge Alito?
I would, and I should say that after Judge Alito left my office, which was late in 1985, I think I've spoken to him 3 times and then maybe 15 words. So it's a guess there as it was with Roberts. But yes, that would be my prediction.
Thank you. Now, my question of anyone who would care to answer is about the value of a presidential signing statement. If it is true, and it is, that the legislature passes legislation, makes findings of fact, that legislative intent is generally based on those who formulate the legislation and pass it, does a presidential signing statement shape the law?
I think that this has been much misunderstood here, too. The Presidential Signing Statement initiative, which I was involved in, I must say, was principally devised to curb the abuses of legislative history and legislative reports in which staff often, and I'm afraid we continue to see that, with the assistance of outside groups and lobbyists, different groups, different lobbyists, but with their assistance, plant little stink bombs in the legislative history, which then flower in later litigation. And the point of the signing statement was, if you like, a kind of air wick against those stink bombs.
But you know,
Senator.
can I just say, stink bombs?
You have aroused
there are
the
plenty.
staff.
There are plenty of. There may be a lot of staff-oriented stink bombs, but the power to inject a poison pill in the legislation is what we see in the signing statement initiative. That is, whatever was the original intent under Charles's tutelage, what's happened under the current administration is totally different. There are something like 100 examples now of references in these signing statements to the unitary executive, and they are being used. They're being used to give the president the kind of control that not only FDR, but all the way back to George Washington, you can find examples of presidents saying, you know, I am the president, this is my government. But it is a big fallacy to say, as my friend Charles Fried did, that this has nothing to do with the power of Congress. Congress often enacts legislation to structure the executive branch and to limit the power of the president as the head of the branch, to tell the limbs of that tree that Charles described and the leaves exactly what to do.
Thank you very
That's
much,
correct.
Senator
Thank
Feinstein.
you
We're
very
gonna
much.
adjourn-
Professor Tribe's right about
we're
that
gonna-
last point.
We're going to adjourn for a few
Senator
minutes.
Specter, I will defer my questions so that we will not have to have the panel come back, if that would be okay, and I will submit some questions.
Well, you're entitled to your round.
But I think in all courtesy to our distinguished panel, this would release them, and I will be happy to submit some questions for the record.
All right, we will proceed in that manner at your suggestion. As I had said earlier, New York Times reporter David Rosenbaum is having a memorial service is being held for him. He was brutally murdered on the streets of Washington very recently. And we will recess for just a few moments, and I'd like the next panel to be ready and the senators to be ready.
This ones always are.
Stand in brief recess.
Quite all right.